All rise.
Hearing in the appeal, I trial.
Before we begin, can I just say two things? First of all, about timing. You may have had the impression that we were going to sit at 2:15 after the short adjournment. I don't know whether that's right, but we propose to sit at 2 o'clock as usual and rise again at 4. The other thing is that I understand that some names have appeared when they shouldn't have done on websites and so on. Just to be perfectly clear, an anonymity order is to be made today to make it plain that the details of parties' names are not to be released. I hope there's no objection to that. We simply propose to make the order.
There's no objection, my Lord.
Thank you very much.
Thank you very much. My Lord, may I introduce the representation?
Yes.
I appear on behalf of the appellant mother, together with my friend Mr. Edward Devereux, who sits immediately to my left. The father is represented by my learned friends, Miss Alison Russell, Queen's Counsel, and Miss Divya Nichols. The child, who appears via children's guardian, is represented by my learned friend, Miss Charlton, who sits to my far right. And the intervener, given permission to intervene in this appeal by your lordships, by the court last week, is represented by my learned friends, Mr. Henry Setright, Queen's Counsel, and Mr. Tirtha Gupta.
We were proposing to hear the intervener after everybody else has spoken. Is that convenient? I think unless anybody objects, it sort of seemed to us we'd rather have all the arguments deployed, because the intervener is taking a neutral position, as we understand, and I think it might make more sense for us to be able to put questions to the intervener once we've heard both sides of the argument. But if anybody objects, please say so.
No, there's no objection. Thank you.
Thank you.
The court will be aware that this is an appeal against an order of the Court of Appeal dated the 21st of July, dismissing an appeal against the decision of His Honour Judge Barnett, sitting as the judge of the Family Division, whereby he held that the court did not have jurisdiction to entertain applications under the Children Act for orders assessing and defining contacts between our client, the mother, and the party's only child, Q, who is now aged 9 years of age. Permission was granted, it was refused, permission to appeal was refused by the Court of Appeal, but granted by this court, I think, on the 28th of September. Could I just, my Lord, mention one or two preliminary matters? First of all, we are extremely grateful to the court for accommodating this case, this appeal so quickly. Of course, as a children's case, it is a matter of some urgency. I hope your Lordship will permit me just to, in particular, thank the court staff, and in particular, if I may, Mrs. de Mambro, for the assistance that they, in particular she, have given us over the last few weeks in the unusual circumstances in which we found ourselves. It's really to the credit of the court that they were able to provide us that assistance despite all the other demands on their time in the last few weeks.
I think it's a mutual process. I think we're very pleased by the way parties have brought the case before us, and the cases have been nicely presented, so we're very grateful.
Thank you.
I'm sure we will pass on your kind words to Mrs. de Mambro, who seems to have left us.
Yes, that's a shame, because she was here a moment ago.
Yes, she was.
Oh, she's behind you. Unfortunately, inevitably, my Lord, there are, as a consequence of this speech, there are one or two errors and omissions. Perhaps the most important, although it's not that important, is that I noticed last night that an out-of-date version, your Lordship's may have spotted this, an out-of-date version of the Family Law Act 1986 is included in the papers at tab 10. And I'm going to ask your usher if he could just distribute. Have they been distributed? You have it. The document that you have there is...
This is the up-to-date
That's
version.
the up-to-date version.
Thank you.
And in particular, if you will see that on page 2, the jurisdiction section, section 2 at the bottom,
Yes.
is in the current form. I'm sorry, my Lord, about that. The intervener was given permission to intervene last week, and their case was produced to us last night, I understand to the court this morning. I should perhaps just mention, if I may, my lord, not for the benefit of the court, but for those in court who may be puzzled by our attire, that we are not wearing robes. That's nothing to do with the speed with which the case has been listed, but because, or may I say for the record, that we are appearing without robes, with the court's permission, for reasons that I could elaborate upon if required. Just to say that it seemed to me, having visited the court 10 days ago, that this would be more comfortable and appropriate. So we are trying it out with your lordship, with the court's permission.
Well, we're perfectly content, and the nature of the proceedings lends it to this form of dress.
But there's some, of course, controversy at the bar about this generally, so I'm not setting any precedent by addressing the court in this fashion. Could I just, I'm sure the papers are in order, broadly speaking, save for one or two errors, but could I just establish that the court should have, first of all, a core volume which comprises, in particular, our case, the respondent's case, the notice of appeal, etc. The papers are in a pastel blue colour, and the authorities in a pastel green colour. The appendix is divided into two, as it were, the key documents of the papers in the case are part 1, other documents part 2, and the authorities are in three volumes, tabbed, continuing through from, in our copies, from 1 to 49, 48, and I understand that the interveners' documents, which I haven't myself seen, follow on 49 onwards. Is that right? I was proposing, my lord, briefly to not in length, to outline the facts of this case, not going much beyond what's set out in the statement of facts, which appears at the second tab in the core bundle. Would that be of assistance to the court?
Yes, it would. I think it's particularly important to identify the date as at which proceedings are said to have begun. That is, the proceedings in which we're involved.
Right.
So perhaps you could
well, my lord, as we go through, I'll see if I can identify that date for the court.
It doesn't seem to me to be entirely straightforward.
No. Well, perhaps we can reach a decision about that as we go through, my lady. The mother is 40 years old, originates from India, is a British citizen. The father is a little younger, originates from Pakistan, but also British citizenship, and the parties were married in 1999. Q, the only child of the parties, was born on the 27th of July 2000, therefore 9 years old, and is a British citizen. The parties separated in 2002 and subsequently divorced. Both parties have now remarried. The matter concerning Q first came before the court in care proceedings in 2001, after he was found to have sustained a number of fractures. And those proceedings took an unusual course, but I don't propose to dwell on them at any length. District Judge Brass, as he then was, after a contested hearing, found that the injuries were non-accidental and that they had been inflicted by the father. That's in a judgment at which we haven't got the tab numbers, I'm sorry to say, my lord, and the statement of facts, so I'll give you some of these as we go through. That's Appendix Part 2, Tab 21, 29th of May. But 7 months later, at another hearing, after hearing further evidence, the district judge reversed that finding and held that the mother and not the father had been responsible for causing those injuries. That's Appendix Part 2, Tab 22. Now, the mother continues to deny...
What's his jurisdiction to do that?
Is the jurisdiction to do that? What is the jurisdiction to do that?
Side issue.
The answer, my lady, is that it is always... I would venture to suggest it's always open to a court in the exercise of their discretion in care proceedings to review findings of fact. It was, that was, I can say, the subject of an appeal, as you see.
Yes.
My lady, there was more evidence before the court. And
Well,
it was
of
on that
course,
basis.
of course. I'm assuming that District Judge Brass did not capriciously change his mind.
No.
Of course not. But that still doesn't answer the question. The normal route,
Appeal.
where it would be an appeal, permission to adduce fresh evidence, and an order for a retrial.
I agree, my lady.
That would be the normal route for doing it. And
I
I merely
agree.
ask why on earth it was done this
Well,
way.
I don't know, my lady. I wasn't instructed at that stage. It has been It has been the matter of a further appeal to the Court of Appeal, but in the event those findings still stand, and that is the factual basis. And of course, that colours everything that's happened since.
When were the divorce proceedings completed?
2002. Completed.
Yeah, I don't have a date for that.
We'll check that.
Separation, you said, was September
Separation
2002.
2002. I'm not sure we've got the decree absolute. You know the answer. And in 2003, my lord. But I will find the precise date over the short adjournment, I'm sorry. So, having made those further findings in December 2002, the care proceedings proceeded to a welfare hearing, as it's known, and the final hearing of that second stage of the care proceedings took place on the 22nd of May, and on that occasion, the judge made a residence order in favour of the father.
We're in 2003 now.
Yes, May 2003.
Yeah.
In the statement of facts, I'm on page 2, paragraph 3. He made a residence order in favour of the father, a supervision order in favour of the local authority for 12 months, and a contact order in favour of the mother.
Is this a Section 8 application at this stage?
At that stage, no. At this stage, yes. Now it is.
At that stage, it would be the orders resolving
Yes.
the care proceedings. The care proceedings come to an end, but they can be resolved by making residence orders and contact orders.
Court has power to make any Section 8 order in any family proceedings, including care
But when it
proceedings.
says the father then applied for permission,
He did. He then applied for permission to.
that's not Section 8 either.
That is
That's
Section 13.
That's Section 13, but it's a contentious matter.
Yes.
On your case, this is an Article 12.3 case, is
Yes.
it? Not an Article 12.1 case.
That's right. Yes.
And on your case, when did the Article 12.3 proceedings begin?
Well, my lord, they began the first article. The first. Well, they can't have begun by definition before Articles 2 revised came into force.
And when was that?
2005.
August 2004, I think.
1st of March 2005.
Is it? Oh.
Shall we? Can I?
What's the date of the father's application for permission to remove the Section 13?
It was a date early 2004, in the mid 2004. I'll check that. And it came, I think it was 4 months after, 6 months after or so, the welfare hearing before Judge Brass.
And the order was made in September 2004,
Yes.
wasn't it?
So it was, we'll check that. At that stage, of course, Article 2 revised not yet in force. And the order made by Mr. Justice Headley is at tab 25 in Appendix 2. And if I may, no, is that right? Yes. Yes. And and may I turn to that in Appendix 2?
Yes, I see. Leave to remove the child from the United Kingdom permanently.
Yeah.
Yeah.
And the order to note about contact on is in the interim, i.e. before the child being removed, weekly supervised visiting contact and telephone contact and such further other supervised visiting contact as may be agreed between the parties. Now, the child went to Pakistan and to anticipate an issue which is raised on the papers in circumstances I'll come on to in a moment. It's the agreed position of the parties, namely the parents, and the guardian, that Q is now habitually resident in Pakistan, whichever test is applied.
Yeah.
Since that date, he has lived in Pakistan, living with extended family, going to school in Pakistan. He has returned to this country on a number of occasions for contact with his mother. She's had some contact in Pakistan as well. But his home is in Pakistan. Now, the first application, and I'm now coming, I think, to the point raised by my Lord Clerk. The first application made by the mother after that was on the 31st of October 2007. She was then acting in person, and it's right that that point should be borne in mind, as was the father at that stage. And the application that she made is, as one would expect of a litigant in person. I hope she'll forgive me. I don't intend to demean her by that phrase. It is not perhaps certainly not couched in the terms which one would expect if a lawyer were involved. So if you look at, in this appendix part 2, tab 27, you see the application that she made.
Is the case number in that the number of existing proceedings, or is it a new number?
Well, your lordship will see that it's, I think that it's FD07, which would be a new number. It looks as though FD04 has been crossed out, which I apprehend was the number of the previous application for permission to remove.
Yes,
it was. So it looks as though she filed it as she filed it with a number purporting to be a continuation of the existing proceedings, but someone, either she, on advice, or the court, changed the number.
What's the proper practice?
Well, the view eventually reached by Judge Barnett, and which we accept is right, is that there was no continuing order for contact after the 2004 proceedings came to an end, and that the proper course was a fresh application. So in answer to my Lord Clerk's question, the first application for a Section 8 order, which comes within the ambit, of course I'm looking retrospectively now, comes in the ambit of Brussels to revised, is this application.
And this is a Section 8 application?
It is, though, as I said, it's couched in terms which are that of a litigant in person, not those used by not terms a lawyer would use. And the matter is, in paragraph 4 of the Statement of Facts, we set out in summary what happened thereafter.
And who are the parties to it?
The parties to it are the mother and father.
Not the child?
Not at that stage. As my Lord may recall, in private law proceedings, private children's law proceedings, Section 8 proceedings, a child is not automatically a party. There are not so-called specified proceedings under the Children Act, which a child is automatically a party. But there is a power in the court to make the child a party and appoint a guardian to represent the child. It is a discretionary power to do that.
Is that in the Act?
Yes.
Do you have the section number to mind?
I don't, off the top of my head.
Find it,
41 is the section which specifies the proceedings.
Section 9A, isn't it?
Section 9. We'll check that. So the and we'll see the child is joined later on in the story. The matter comes first before the court on the 5th.
So on the answer to my question,
sorry,
on your case, when you say that these proceedings were first commenced, the relevant proceedings were first commenced in 07, the one we were just looking at
yes.
tab 27.
Yes.
And on your case, when was the court seized first for the purposes of Article 12.3?
The court was first seized when. Is it service restricted?
No, it's when the court is issued.
On the issue of under English jurisdiction, it's when those proceedings are issued.
So on your case then, under Article 12.3, when do you say the court was first seized? I appreciate there's maybe an issue about whether it is the first seizure, if that's the expression.
31st of October. 31st
You would say the 31st of October?
2007.
Yeah.
And the child was not a party to those proceedings at that moment.
That's right. Briefly, the hearings that took place, there was a hearing on the 5th of November, both parties attended, a matter adjourned, and then on the 12th of December 2007, both parties attended again in person for a conciliation hearing, after which the judge, Deputy District Judge Crowther, made an order, and that is at 30 in the same Appendix 2. So this is an agreed order as to contact. And the court will see, sets out in some detail what is to happen. We've got the agreement actually. Is the agreement actually in it? There is a, may I just turn around? An agreement. There is an agreement. Is there an additional page? Or is it as at the bottom? I think it is actually the body. It says as amended and attached here too. I would expect there therefore to be another page somewhere. But at any rate, the basis of the order agreed is as set out in the body on that page.
So there should be another document.
I think there is. I think there is another document. We'll check. But the substance of the order is as set out at the bottom of that page.
And this is an agreement between the parents,
It is, and embodied in the court order.
but no agreement on behalf of the child.
No. Child not a party at that point.
We should make it clear that it's extremely unusual for children to be separately represented in Section 8 proceedings.
Yes.
So there's nothing unusual about doing things in this way.
I quite follow that. It's just one just has to fit it in somehow.
Yes, of course, because it is an issue which arises. Now, the mother then files a further application, still acting in person, which is the next page, tab 31, on the 15th of April 2008. And as you will see, what she is seeking to do is to, quote, enforce and vary contact order to ensure Q is in UK to facilitate contact and explore order unsupervised assessment with LA, local authority, as per attached. I don't want to go through too much of the detail of this unless the court wishes to do so. The important point is that this is an application to effectively to enforce and vary the order that she'd got in December by agreement. That comes before a district judge, then she's on a Judge Turner.
Do we have as per attached?
Again, I don't know that we do, my lord, and I will see if we can get hold of that.
We do, because I think it's, is it not the following tab?
Oh, hang on,
32.
yes, it's 32, okay. Sorry.
It's the supplemental information.
Yes, of course, it's the C1A, is it?
Yeah.
Is it then, it's changed, isn't it? C1A.
Yes, it's the same date, isn't it?
And then the details of the assessment that she was talking about is in the typed page, at the last page on page 30, in tab 32. So it comes before district judge, then Judge Turner father didn't attend, and then a hearing, another district judge hearing, and eventually ends up before Mr. Justice Headley, again, on the 16th and 17th of June 2008. And this document is now in bundle part 1 of the appendix at tab 7 and 8 for the smaller appendix. The parties were still in person. And the order made by, this is the smaller appendix bundle, light blue. Might it be the one? That one.
Yes, it's a very thin, or comparatively
It's
thin.
finished, isn't it?
Part one.
It'll also be at the back of the core volume.
It's tab 7 is the order made by Mr. Justice Headley, and the order that the first order he makes is that he appoints a guardian for the child. Doesn't formally make an order joining the child as a party, but appoints a guardian.
I'm glad I don't have the appendix. What was the date of the order? Yeah, don't worry about it.
The 17th of June. Are our papers, are yours organised differently?
It should be at the back of the core volume. It doesn't
Is your
have tab
appendix one
numbers,
back of
that's
the
the
core
problem.
volume? Yes,
It
yes.
would be sufficient if you give me the date.
Sorry, my lord. 17th of June, 2008.
Okay.
Well, there is an order at 7.37, but I don't know.
I think it's 7.39.
39,
I think
yeah.
it's the right one.
Yeah.
And then
I think it is
the
7.39.
judgment of Mr. Justice Headley is
Just a moment. You pointed out that the order appoints a guardian,
yes,
but doesn't join the child as a party.
doesn't say so.
Yeah, well, my recollection is that it's possible to do that. That it is possible to appoint a guardian for the child in family proceedings without making the child a party. But we'd need to check that,
We do.
bearing in mind the technicalities we're involved in these proceedings.
Yes. And then the order, to just go on to the order requires the father to bring the child to the jurisdiction for contact the following year, i.e. this June, for 8 weeks, June and July 2009, and provides the mother to have reasonable contact with the child, either as agreed or as ordered by the court, with reasonable telephone contact with the child in Pakistan, and the mother to have liberty to have visiting contact with the child in Pakistan, the father having assured the court that she will be safe with his family. And the judgment, hopefully, in my hope, is immediately behind that. In my tab 8 in Appendix Part 1, I don't know what tab number it is in the court bundle. It's the next document.
Yes.
Is Mr. Justice Headley's judgment. Now, much of this judgment deals with issues that arose because the judge was hearing the parties in person. And again, I don't propose to go through it in full, unless the court wishes me to do so, but he recites the history, some of the evidence he'd heard. He'd asked the senior Kafkas officer in the High Court team, Mr. Mellor, to attend, to help, see the parties and discuss matters. He recites what Mr. Mellor said to him, paragraph 17 of the judgment. And then paragraph 19, he says, I have no doubt that the court ought to give further consideration as to how this case is to be managed in the long term, it being abundantly obvious to me, if not to the parties, that trying to deal with it in the kind of timescale attempted this time round in such a fraught case merely underlines the difficulties that the court is inevitably confronted with. It is also my intention to crystallise out the statement of aspiration in paragraph 5 of the order of the 12th of December 2007 by directing the attendance of K, child, in this jurisdiction in 2009 on the basis that that is apparently uncontentious between the parties, and indeed may not be just a holiday for holiday but a return, in which case the court inevitably needs to be involved because there will be questions of future contact to be considered. The mother has received an assurance from the London Borough of Newham that they would undertake an assessment of her capacity to have unsupervised contact, which must be her first aspiration. If that is granted, where it will lead is of course a matter that stretches sufficiently far in the future to be very unwise for the court to make any comment about now, and that is an assessment to which of course she must be entitled. and is an assessment which is, of course, futile without the presence of the child, or at least it could be started, but it cannot be concluded without the presence of the child. And so those are matters about which I have no doubt, which I will in due course reduce into order form. That then leaves the issue about this summer, i.e. context in summer 2008, upon which, as upon many issues, the parties remain hopelessly divided. The learned judge then recites the parties' arguments, paragraph 24 and 25. 26. Now, I do not for one moment underestimate the importance of this matter to the parents. On the face of it, the mother makes a perfectly reasonable application. On the face of it, the father raises not unreasonable objections to the visit taking place this summer. One simply has to recognise that this is so, but one also has to acknowledge that it is generally desirable and strongly in the interests of a child to maintain a proper relationship with both his parents, both of whom, of course, at this stage live in the United Kingdom, which he does not. And so one recognises that in the ordinary circumstances it is perfectly reasonable that matters should take place as contemplated. The trouble is, there's nothing ordinary about this case at all. The relationships are vindictive, the willingness to discuss is wholly absent, nobody is able to speak without making endless allegations against each other, and the whole thing is hopelessly fraught. That, of course, immediately leads me to ask myself, what on earth is it I'm bringing this child into if I were to require him to return? And I fear that what happened last time he was here, and there was an issue about what happened to him, which I won't go into, whichever account one chooses to look at, whether the mother or father does nothing but add to the concern. Then he makes further comments about the parents. And then he goes on paragraph 29. I have, of course, no power whatever to compel anyone in Pakistan to do anything. The only power I have is to compel the mother or the father by reason of their being parents, and therefore subject to the jurisdiction of the court. No one else is, because, of course, the child is entirely lawfully in Pakistan. And indeed it is unusual that the court should be retaining jurisdiction in this case, because, of course, the child is habitually resident in Pakistan. And were this a European case, the court would be positively deprived of jurisdiction by the structure of European parenting law. But it is not, and the court undoubtedly does have jurisdiction, because both parties have not only submitted to the jurisdiction, but have actually invoked it on a number of occasions. And so the question of jurisdiction of itself does not present a problem in this case, though, of course, the question of enforcement of orders might. Well, I've considered the implications of that paragraph on a number of occasions over recent months. Were I to remove the two references to European, then there would be no difficulty. We'll come back to the interpretation, if I may, a little later. But the point I want to emphasise is that the learned judge relied in his reaching the conclusion that the court undoubtedly does have jurisdiction on the fact that the parties had not only submitted to the jurisdiction, but had actually invoked it on a number of occasions.
That's the parents.
The parents, who were then, of course, up to the moment he made the order, the parties. Now, that, and he then goes on to decide that it's impractical for the child to be brought to the country in 2008. The father agreed to bring the child in 2009, didn't agree in 2008. Mr. Justice Headley ruled that it was impractical for him to make an order at that date, 17th of June, for that to happen.
But he then directed, as he states in paragraph 31.
Indeed.
Yes, he does.
So this is
He says that the child should
He
become a
says-
party, even though it's not in the
That's
order.
right.
yeah. So this is the stage at which the child becomes a party,
Yes, it doesn't say so in the order.
but still we can see it in the
Yeah.
reasons.
And then he explains...
That's right, is it? That is right, it is the order, is it? Maybe it doesn't really matter, actually. But there's been quite a lot of argument about just exactly when, at any rate, for the purpose of seizing.
I mean, it's a direction. That's good enough, is it?
For my part, my Lord, we had acted on the basis the child has from this point, been a party. It doesn't say so in the order. What distinction would there be represented by a guardian, but not a party?
Well, I asked the question because my recollection is that the law does provide for that, but given that this is what Mr. Justice Headley said in his judgment, I suspect that if anybody applied for the order to be amended under the slip rule, it would be done.
Yes.
So,
I will, for my own peace of mind, if nothing else, check your ladyship. I'm always very anxious about disagreeing with the ladyship about the interpretation of the Children Act for obvious reasons. I will check to see if it's right that a guardian can be appointed, as your ladyship postulated, without a child being a party.
Well, I think the order of events, actually, if I read this correctly, is that the guardian was going to be appointed first, and then he says, thereupon, the child. Am I not right? It's the last line of paragraph 31. And he should, thereupon, become a party to these proceedings. So you've got to have the guardian first. Does that make sense? That's what he seems to be saying.
Would they not if you forget, in the ordinary course of events, the guardian is only appointed when for a party under disability in guardian ad litem.
Yes. Well, he's asking Kafkas to appoint the guardian.
But that's because Kafkas actually supplies guardians. The logical order is to order that the child become a party, and that the child then have a guardian who could be Kafkas or could be from somebody else. I mean, that's the logical order of doing it.
Speaking for myself, it would be of assistance to look at Rule 9.5 of the Family Proceedings Rules and indeed any other rule or statutory provision which might bear on this question.
I think it's section 9.
May I do that after?
Yes, certainly.
After the shortage?
Yes, certainly.
I don't propose to go through the rest of the judgment because actually he just sets out what he's done, which is repeated in the order. So that was the order in June 2000.
So are these fresh proceedings now, within the meaning of article, on your case, within the meaning of the...
No, they're not.
They're not.
Proceedings. It's still the start date was the first date for these proceedings was the date of the mother's first application.
It still bears, for what it's worth, the same case number as was on the mother's application.
This is your lordship will recall that the second, if I may call it, homemade application by the mother was to enforce and vary contact, plus other things. And in other words, the order made after the conciliation hearing, Deputy Registrar Crowd in December 2007. So it is a continuation of the proceedings that were started in 2007, as my Lord Hope has reminded us. It has bears the same number. And what happens thereafter is also a working out of what had happened of that order. So, if I may, what happened thereafter, briefly, is that the mother went to Pakistan and had contact with the child in Pakistan for about 3 weeks in July 2008. And for the record, that's the last time she's seen the child.
But just to follow this as we go along, these are the proceedings begun in 2007, which are the relevant proceedings under Article 12.3. Is that right?
Yes, my Lord.
And on your case, are the only relevant parties to those proceedings the parents?
Well,
On the hypothesis that there are only one set of proceedings and that seized means first seized, the logic would be that they are.
Yes.
Another possibility is that they somehow become new proceedings when the child is joined.
Yeah,
because otherwise it makes very little sense of the expression all the parties, but we'll come back to that. But your case is, it's the 2007 proceedings. We're only concerned with Article 12.3, not Article 12.1. Is that right?
Yes.
And that the only parties to the proceedings are the parents. So whether the child ever agreed anything is irrelevant. Is that right?
That is
your case.
That is, jumping ahead, that is my case on unequivocal acceptance.
Well, under Article 3.
Under Article 12.
Sorry, 12.3.
And it's the point of time is identified in 12.3, and it's really, your point is first seized.
Yes.
You look at the state of affairs as at October 2007.
Yes. And that, of course, is a major part of our complaint about the Court of Appeal decision.
And their view is, well, these are continuing proceedings and the guardian doesn't come in until later, but you ought to take account of his position as well.
Yes, well, of course I shall deal with that in
Yes,
all
of
those
course.
arguments in due course, but that is obviously the focus of my Lord Clark's, one of the focuses of my Lord Clark's questions, to establish who were the parties, when the court was seized, and who were the parties at that point. And as you know, we say it's a point in time, first seized, and you look at the parties at that point.
Yes.
But I'll come back to develop those arguments in due course.
Now, we move into 2009 next, do we?
Yes. 2009, my Lord, I'm on now paragraph 10 of the statement of facts. I'll give you some more references here.
Yeah.
Matter came before Mr. Stephen Bellamy, Queen's Counsel, sitting as a Deputy Judge of the Division. And at this stage, for the first time, both parties are legally represented. And for that hearing, counsel then instructed on behalf of the father, filed two position statements, and in the second of those, which is at tab 20 in Appendix 2, the largest of the pale blue bundles, he says on the first page, paragraph 4, A, the court has retained jurisdiction in this case, and the father accepts the court's jurisdiction. However, given that the child is habitually resident in Pakistan and is living there permanently in the day-to-day care of his paternal aunt and grandparents, the father is not in a position to effect any order for Q to come to the UK, and as recognised by the court itself, it is not possible to enforce any order for contact against those living in Pakistan. And then at paragraph 28, he repeats, well, paragraph 22, he has a section headed jurisdiction on page 5. Recites in paragraph 25 what he says the law is. Section 8, the jurisdiction is based either on the Family Law Act 1986, I think there must be an or intended, or the Council regulation, Russell's to revise. In paragraph 26, given the child is in Pakistan, the Council regulation is not applicable, and the court needs to look at to the physical presence for which residents have found jurisdiction. Q is not physically present in the jurisdiction, and no party seeking to suggest he is habitually resident. Habitually resident is not statutorily defined. Its meaning is essentially based on the facts and looking at all the circumstances of the case. Its meaning is similar to ordinary residence. It requires an appreciable period of time to settle to live in a particular place. Pakistan is clearly his place of habitual residence. There is, however, case law which provides a basis for jurisdiction, namely where there is an application to vary a Section 8 order validly made in the UK, notwithstanding the child was neither habitually resident or present in the UK, see Res, in which the court had jurisdiction even though the child had moved to live in Holland since the original order was made. The father accepts the court has retained jurisdiction to make orders directed towards himself in relation to contact. The difficulty is that any orders in relation to contact cannot be enforced. As Mr. Justice Headley recognised, he could not compel anyone who lives in Pakistan to do anything. And following that...
Just before you leave there, it's clear, isn't it, from paragraph 23 of this position statement, it was accepted on the part of the father that he had given an undertaking to return the child in order to do so.
Yes.
That contrasts somewhat with the assertion in paragraph 4 that he's not in a position to fulfil that undertaking. In other words, was an undertaking incapable of fulfilment, if this position paper is correct.
Yes, if it's correct.
Well, it assumes that he's not in a position to say to those who are looking after Kadir in Pakistan, I'm dad, let me have him.
Well, that's would appear to be one interpretation. Not clear exactly what he means, maybe. But that's what he says. And if we look at the order, which is, I'm sorry.
He seems to be saying at the same time that the court retains jurisdiction over him in persona in relation to the undertaking he gave earlier, and could presumably therefore enforce it, enter its attempt to do so by proceedings in persona or orders in persona against the father.
Yes, and indeed, Mr.
That's
Justice.
independent of what the regulation says.
Mr. Justice Headley had made a similar observation, as we've seen. The order made by the Deputy Judge is at tab 6 in the Appendix 1 bundle, so it's in your core. If it's in your core bundle, it's just before Mr. Justice Headley's order. Sorry about the eccentric ordering. Do you have the order of Mr. Bellamy's order? Mr. Bellamy, it's
Yes.
not dated, actually.
It's the 2nd of March.
It is the 2nd of March. Oh, it's dated on the second page. So, over page. And he says, the order he makes is, upon the court considering that it retains jurisdiction, and upon the solicitors for the first respondent father, retains jurisdiction to make orders in respect of Q, and upon the solicitors for the father agreeing and undertaking to issue the application to set aside paragraph 4 of the order of Mr. Justice Headley within a week. Order 1, paragraph 4 be amended under the slip rule to read as follows: the father to bring or cause the child to be brought into the jurisdiction of England and Wales on a date not later than the 4th of June, and to remain in the jurisdiction of the 30th of July. The matter be listed on the 12th of March 2009, time is 1 hour at risk for consideration. If anyone should conduct a welfare assessment of Q in Pakistan to include consideration of the, sorry, it's gone off the end there, of various matters, and then further directions about the father's application. And pursuant to his undertaking, the father issued an application, which is in the other appendix bundle at tab 38. So this is an application, look at tab 38, C2, which is an application for interim, the form for interim orders in continuing proceedings, tab 38. The case has the same number, ongoing number, FDO 7 number, issued on the 4th of March, and the order the father seeks is set out at paragraph 2. He seeks to set aside or discharge the order requiring him to bring the child to the jurisdiction. That summer, effectively. So he invokes the jurisdiction of the court to vary the order made by Mr. Justice Headley the previous year. And the reason he does so is set out at paragraph 5. For the reasons set out in the applicant's position statement in this matter, which we've just looked at, well, we haven't looked at all of it, but that's the document. The applicant contends that it is no longer in the child's best interest or necessarily practically possible for the child to be brought to the UK this summer. Necessarily practically possible. Now, the matter then comes before Mrs. Justice Black on the 12th of March, and she sets it down for hearing on the 5th of May. In the course of that hearing, we understand, I don't think any of counsel present now were instructed at that point, is that right? In the course of that hearing, Mrs. Justice Black raised the question of whether the court had jurisdiction to make orders in respect of Q. And thus the matter comes before His Honour Judge Barnett, sitting as a Deputy Judge of the Division on the 5th and 6th of May, and Mr. Devereux is then instructed, and Mrs. Nichols.
Miss Badia. Yes.
Right. Sorry. Miss Badia, I do apologise, I misintroduced Miss Badia. Miss Badia appears as a junior, I do apologise, I gave her a married name. Miss Badia appears on behalf led by Miss Russell, and she appeared as junior counsel before Judge Barnes on the 5th and 6th of May. Is that right? Yes. Now, the attention was then given to the question of jurisdiction in detail, and it was agreed at that stage by all counsel then acting that the case fell outside the provisions of Brussels II revised, so that the question of whether the court had jurisdiction to make orders about the mother's contact with Q fell to be decided by reference to the residual, what I've called the residual domestic rules under the Family Law Act 1986. Would it just be helpful just to, as you haven't had until this morning the up-to-date version, just to look at section 2 of the Family Law Act as amended, which is this bulky document clipped by a staple at the top. Second page.
I was going to say, this has come off Westlaw, hasn't it?
It has.
I recognise the style.
We've got a trial run of Westlaw. We're on trial in our chambers at the moment, so we're using it to the full, my lady. Although whether it's helpful to have it this way, I don't know. But that's the way it's set out. A court in England and Wales shall not make a section 11A order. Does the court wish me to just deal with what that is? I'll come back to that. A section 11A order with respect to a child, unless A, it has jurisdiction under the council regulation, or B, the council regulation does not apply, but 1, the question of making the order arises in connection with matrimonial proceedings or civil partnership proceedings, and the condition in section 2A of this Act is satisfied, or 2, the condition in section 3 of this Act is satisfied. Section 2A at the bottom of the page, so at page 3, the condition referred to in section 2.1 of this Act is that the proceedings are proceedings in respect of the marriage or civil partnership of the parents of the child concerned, and A, the proceedings are proceedings for divorce or nullity or dissolution or annulment of a civil partnership and are continuing. B, the proceedings are proceedings for judicial separation and are continuing, and the jurisdiction of the court is not excluded by subsection 2 below. I won't read on, my Lord, because section 2A did not and does not apply. No. Well, never. We say never. In fact, never applied and wasn't argued before Judge Barnett.
So we go to section 3.
Section 3, habitual residence or presence of the child. The condition referred to in section 2.1b2 of this Act is that on the relevant date, the child concerned, A, is habitually resident in England and Wales, or B, is present in England and Wales and is not habitually resident in any part of the United Kingdom, and in either case the jurisdiction of the court is not excluded by subsection 2 below, and subsection 2 excludes jurisdiction if proceedings are continuing in other courts in the United Kingdom.
And the relevant date is defined where?
Section 7. 7? It's 7, isn't it? The relevant date, 7c, page 8, means in relation to the making or variation of an order, 1, when application is made for an order to be made or varied, the date on which the application or first application of 2 or more are determined, and 2, where no such application is made, the date on which the order is considering whether to make or, as the case may be, vary the order. I said I'd say what a section 11A order is. If you go back to the first page, section 11A is, well, section 11A is a section 8 order, other than an order varying or discharging such an order.
So once section 8 order has been made, any application for a different order will be a variation and not a fresh application.
Yes. So the matter, the argument was at that stage that the court had jurisdiction under the residual domestic rules. Mother argued that it did. Father argued that it did not, that there wasn't an ongoing variation, that the order, that there was a fresh application following the fresh application to be made following the child's removal to Pakistan, and that in those circumstances the court had lost jurisdiction because the habitual residence requirement could no longer be satisfied. In addition, in the course of that argument, the judge...
When did this come into force?
The version that you have, the latest version, came into force, is following the implementation of Brussels II revised in 2005 by virtue of the European Community's jurisdiction and judgments in matrimonial and parental responsibility matters, regulations 2005/265, regulation 8.3. I think that may be in the...
It's in the footnotes.
Yes, it is. There it is. Footnote 5.
Yeah. I mean, the introduction of Brussels II revised came as a result of Brussels II revised in March of 2005.
That's right.
There was a further amendment to deal with the Adoption and Children Act.
The Children Adoption Act. We have, yes.
The Adoption and Children Act. It says here.
It's right, you're right. Yes.
It's very easy to get them confused. It matters
no,
not.
I think it is the Children Adoption Act. It's the one that we haven't... Well, I thought we wouldn't trouble the court with this, but the full of section 5 includes reference to the condition activities, directions and conditions provisions of the Children Adoption Act 2006. It really isn't, my lady, a matter for the court. But there was subsequently a further amendment to do that.
I'm sure that's true, but all I was seeking to explain was why this version in force from December 30th, 2005 to the present appears at the top of this. This is where Westlaw is helpful.
So I'm discovering.
But you have then to work out, well, Brussels II revised came in earlier than that, so why is this version?
Yes.
And it's explained in the footnotes. That's all.
Yes.
That's
But
the previous version was basically the same, but without, in substance the same, but without the reference to Brussels II revised, as a general proposition.
Well, if you would like to look at we have that version accidentally in the bundle we've sent to you. So that is at tab 10 in the authorities bundle. So volume 1 of the authorities bundle, tab 10.
Oh, of course, it had it referred to the council regulation for the purpose of the jurisdiction in matrimonial proceedings.
Different regulation.
Different regulation, the earlier regulation.
Yes.
Yeah.
If you look at tab, just so to try and make it less unclear, tab 10 contains the version of the Family Law Act 1986 that was in force before the 2005 amendment, which was implemented to take account of Brussels II revised. As we will go on to consider later, and the court knows, Brussels II revised is the successor to an early regulation, Brussels II, and this previous version of the Family Law Act 1986 was itself the result of an earlier amendment to take account of the earlier regulation. So when we see at paragraph 2 on page 4 of the document at tab 10, section 2 then read as follows, that is, immediately prior to April 2005, a court in England and Wales shall not have jurisdiction to make a section 11A order with respect to a child in or in connection with matrimonial proceedings in England and Wales unless A, the child concerned is a child of both parties to the matrimonial proceedings and the court has jurisdiction to entertain those proceedings by virtue of the council regulation, which of course is Brussels II, or B, the condition in section 2A of this Act is satisfied. 2, a court in England and Wales shall not have jurisdiction to make a section 11A order in a non-matrimonial case, that is to say, where the condition in section 2A of this Act is not satisfied, unless the condition in section 3 of this Act is satisfied. And the reason for that distinction at that stage was, of course, that Brussels II was a regulation dealing with matrimonial cases and only covered issues of parental responsibility that arose in the context of such matrimonial proceedings. So,
So the effect of the change, previously, the court could make an, well, still now, can make an order in the context of matrimonial proceedings in relation to the child. So under section 22A. So long as the proceedings are continuing.
no. If we we compare the two versions, you will see. If we compare the two versions, I've shut mine up. You have the two. How fortuitous that we've got those copies. To the previous law provided in matrimonial cases, it would appear for alternatives. It sets out as pure alternatives. Either you bring yourself, either in a matrimonial case, either you, the child falls within 2.1a or 2.1b. In either case, the court has jurisdiction. But under the new draft, it's drafted rather differently and encompasses, sweeps away the distinction between matrimonial and non-matrimonial cases, as does the regulation itself, as we'll see later, and instead provides as follows: a court in England and Wales shall not make a Section 1.1a order with respect to a child unless A, it has jurisdiction under the regulation, or B, the regulation does not apply, but the question of making the order arises or connection with matrimonial proceedings, or the condition in Section 3 is satisfied.
And you say the regulation does apply, the court has jurisdiction under the regulation, and so we don't need to look at but.
That's right. And I say...
Rather different from what you were saying, of course, or was being said on behalf of Mum previously.
I'm going to show Mr. Difference is very aware of that. It is different, but it illustrates what I'm not giving evidence. It illustrates the obscurity of this area of the law and the fact that it's not perhaps generally understood, the jurisdictional rules. It's not now controversial, or it's not being contested by those who appear on behalf of father. What we say about the hierarchical arrangement of the jurisdictional rules is right. In other words, as the regulation itself demonstrates, and I'll come on to this later, and as is confirmed by the current drafting of the section, you look first of all to see if you've got jurisdiction under Brussels II revised, and only if you haven't do you consider whether you've got jurisdiction under the residual rules.
But doesn't it go further than that? Only if the regulation doesn't apply, which is different from saying you don't have jurisdiction under it, because the whole purpose of putting council regulation on top is that under the council regulation you might not have jurisdiction.
Well, of course...
Another EU country would, in which case B couldn't apply.
Yes, that's
so
right.
it's not you don't have jurisdiction under council regulation, or it is
that it doesn't apply.
It doesn't apply.
Yes.
That's a very important distinction.
Yes, your ladyship is right to correct me. We'll come on to look at the regulation in a moment.
Supposing the regulation says Germany has jurisdiction.
Yeah.
We don't have jurisdiction, but the regulation applies, and so we can't go hunting for some other basis for jurisdiction.
That's right. That is the hierarchical. We'll look at the detail of the hierarchy. It's spelled out very clearly in the practice guide, which we'll come on to in a moment. Now, just to go on then with the story, the history, in the course of that argument, the judge asked for further submissions on the issue of forum non-conveniens. In other words, were he to decide that the court had jurisdiction, as argued for on behalf of the mother, he wanted then to consider and be helped as to whether or not he should grant a stay on the grounds of forum non-conveniens, stay of the proceedings. And arguments were addressed on that on the next day. And on that point, the mother, of course, contended that these courts were the convenient forum. And the guardian's position is interesting. She had he had argued against the jurisdictional point, in other words, submitting that the court did not have jurisdiction. But if he was wrong about that, he argued that it was the convenient forum. Judge Barnett's judgment was handed down on the 28th of May, and he held that the court had no jurisdiction to entertain the applications. However, he further held that if there was jurisdiction to entertain the applications, he would have refused to grant a stay of the applications on the grounds of forum non-conveniens. I mention that because I think Lord Justice Thorpe, with great respect, has erred in paragraph 9 of his judgment when he says, if we look at the appeal judgment, which is with tab 2, so it's immediately, it's in your call, in your lordship, in your court's copy, it's in tab, it's in the call bundle. He says at paragraph 9,
That's right.
he's corrected.
Yeah.
He's corrected Lord Justice Thorpe. I have reread his judgment, I assure the court, but that's not what he said when he was giving it extempore.
I see. So there's nothing wrong with that.
I was perhaps too concerned to check that he had not changed what he said about the Papistine Protocol.
Right.
I'll come on to that later. He hasn't changed that, but he has corrected himself. I apologise to him in paragraph, in what he says about paragraph. He's got it right, in other words, and I got it wrong. So we then appealed, Mother then appealed, and well, the course of, we've got the judgment of the Court of Appeal handy, and that sets out what happened thereafter. I was then instructed, the argument of the Court of Appeal was framed very differently. We put forward the Brussels II revised arguments, which we now advance before this court. We argued that the question of jurisdiction fell first to be considered under Brussels II revised. In other words, the hierarchical order, as we've looked at already, needed to be considered. That on that basis, we submitted that the court had power, that there was a power of prorogation under Article 12.3. That extended to all children, in theory, wherever they are, wasn't confined to any sort of European ambit. That the requirements for prorogation in Article 12 were satisfied, and we also, in our written case, although this wasn't developed in oral argument, we argued that, following the decision of the European Court in the Owusu case, the principle of forum non-conveniens did not apply in cases where the jurisdiction was based on Brussels regulations. Alternatively, of course, we relied on Judge Barnett's findings that this was the convenient forum. The Court of Appeal didn't go on to consider forum non-conveniens because they determined that the court did not have jurisdiction. The court rejected the submission that the prorogation powers under Article 12.3 provisions extended to children who were habitually resident outside the EU. The court held in any event we didn't satisfy the hurdles for prorogation under Article 12.3 and dismissed the appeal. Hence our appeal to this court. And that's all I propose to say about the facts or history of the case at this stage. There may be other matters which we need to look at in due course.
Thank you very much.
Unless the court wishes me to go back over anything further that we've omitted.
No, that's very helpful.
On page 9 of the statement of issues, facts and issues, I outline the issues. These are agreed, although I will just mention Ms. Russell's, what I infer is a slight amendment to the agreement from her document. Obviously, we have to do it very quickly to get this this document right. Broadly speaking, these are the issues that are raised before you. We raised the issues, and we put before the court the issues under three headings: the primacy of the Brussels II revised provisions of jurisdiction, the scope and application of the provisions of Article 12 of Brussels II revised as to prorogation, and the application of the doctrine of forum non-convenience. Now, taking those in turn, I'm on page 9 of my statement of facts document, paragraph 2. The first issue we raise is the primacy of the Brussels II revised provisions. Lord, that is not controversial as between the parties' representatives that appear before you. As you will see from Miss Russell's document, she accepts, on behalf of her client, our submissions as to the primacy of the Brussels II revised provisions. But I will spend a little time just outlining our argument about that in due course because of what follows from it. Secondly, we identify a number of matters arising under Article 12.3 itself, and this is at the heart of the case. Paragraph 4, the first we mentioned is the meaning of habitual residence. Now, that point, strictly speaking, doesn't arise in this case because all parties are agreed that whatever test is applied, Q is habitually resident in Pakistan and his parents are habitually resident in this country. In other words, we're not seeking to float what in our view would be highly optimistic arguments that Q had retained two habitual residences. We say the factual position is clear. However, and it will be Mr. Devereux who will be developing these arguments if called on by the court, we invite the court to consider whether it would be helpful and appropriate to consider issues of habitual residence that arise in Brussels law as it currently is. And of course, that really goes as to whether the court takes up that suggestion is entirely a matter for the court. We don't know whether this court, in its new role, will wish to take advantage of such invitations.
Do you want us to say whether or not we're enthusiastic now?
I hope not. I would have thought we could wait until you sit down and
I was going to
call upon it.
I was going to say that
Yes, I know.
the enticement is the blandishments are not just coming from us, but they're coming from the intervener, Mr.
Yeah, well, I think the other point to bear in mind is we have only 2 days for this case, and therefore we are to some extent time limited.
We are, of course. It doesn't strictly speaking arise in this case. The law is interesting and has developed in recent authorities, we invite the court to look at it if it's got time. But I'll move on for the moment.
Anything that we might say would be obiter in any event.
It would.
So what's the point?
Well, it's a question.
You could say it was obiter and wrong.
Well, shall we move on?
Shall I move on?
Experience that's not unknown.
Yes, the court will perhaps apprehend that for our part, and for my part in particular, I'm concerned the court focuses above all on the issues which arise in this case, which are by themselves equally interesting and perhaps certainly are important and definitely arise in this case. The second of those is, of course, the proper interpretation of Article 12.3 with 12.4, and we focused on the meaning of the phrase third state, and that is a hotly disputed topic between the learned friend and myself. Then we consider the two hurdles under the prorogation provisions which are relevant in this case. The proper interpretation of the phrase, quote, the jurisdiction of the court has been accepted expressly or otherwise in an unequivocal manner at the time the court is seized, which involves two elements: at the time this court is seized and unequivocal acceptance. and then the phrase, the interpretation of the phrase, in the best interests of the child. And then the fifth point.
Sorry, could I have the fourth point again? I beg your
I'm
pardon.
sorry. The third and fourth points are the
Yeah.
two hurdles in the prorogation powers, as I call them. The hurdles
Right.
being,
Yes.
we have to satisfy the court that the jurisdiction has been accepted expressly or otherwise in unequivocal manner at the time the court is seized. And we have to satisfy the phrase in the best interest of the child,
Yes.
whatever that means, and whenever it falls to be determined. The fifth point we raise is whether the Court of Appeal was correct, as we say it did, to construe the provisions of Article 12 narrowly on policy grounds identified by Lord Justice Thorpe, in particular his reference to the Pakistan Protocol.
Presumably that logically would be a prior point.
Logically, I put it at the end, haven't I? I'll take it whenever the court would find it helpful. But you're right, my lord. The final heading is forum non-convenience. Now, again on this point, there isn't an issue between the parties for the purposes of this appeal. And Miss Russell will correct me if I'm summarising her case incorrectly. She accepts, as I understand it, that she accepts the thrust of our submissions about forum non-convenience so far as Brussels 2 revised is concerned. Her case is that the issues which are covered would normally be covered under the doctrine of forum non-convenience are adequately catered for by other provisions within the regulation. And of course one can immediately see similarities between the forum non-convenience test and the best interests test. But I won't stray into that argument at that point. We'll come on to that in due course. So those are the issues. Well, for our part, we propose to concentrate on the issues at the heart of the case. But I do want to begin by saying a little bit, and I'm turning now back to my case, about the primacy of the jurisdictional rules.
Well, it's set out, if I may say so, very clearly in your written case. So, in view of the time element,
Shall I move on?
don't feel you have to go into great detail if it's already written down.
Thank you. Well, I won't. Could I just draw your attention, then, my lord, to the practice guide. Now, that is in tab 2 in the authorities bundle. So, green files, volume 1, tab 2, page 12. Page 12. A court seized with a request concerning parental responsibility has to make the following analysis. Do I have jurisdiction pursuant to the general rule, Article 8? Oh, my lord, I have, of course, not. I'm sorry. Does your lordship wish me in any way to recite or go through the provisions of Brussels 2 revised, which we will be looking at?
Well, we've all read it. It's set out very clearly, for example, in the Court of Appeal's case is quoted in full.
It is, I've quoted verbatim in my...
Yes, I'm taking it that we concentrate on Article 12.
Yes.
If there's anything else, I confess I haven't gone beyond Article 12 myself.
Well, we don't have to. But reverting then to my submissions, but looking at the flow chart,
Right.
the court asks, do I have jurisdiction pursuant to the general rule being habitual residence of the child? Yes, I have jurisdiction. If no, do I have jurisdiction to Articles 9 to 10, 12, or 13? If yes, I have jurisdiction. If no, does another court, a court of another member state, have jurisdiction under the regulation, Article 17? If yes, and this is Lady Hale's point, I must declare of my own motion that I do not have jurisdiction. It's only if the answer to all those questions is no, that no court is competent under the regulation, and in those circumstances, I, the judge, can exercise any jurisdiction available under my national law, the residual law. So the effect of the regulation is, in my submission, quite radical, because it has confined the domestic rules about jurisdiction to the very relatively narrow circumstances in which none of those questions is answered yes before that. In other words, it's only if the court does not have jurisdiction under the various rules under the regulation that it can exercise its jurisdiction under the domestic laws under the Family Law Act 1986.
Of course, the main point about the Family Law Act 1986 was not to fix jurisdiction as between courts in the United Kingdom and other courts. It was the result of a treaty between the English and the Scots as to jurisdiction within the United Kingdom.
Yeah.
It did, incidentally, replace the old common law rules on jurisdiction vis-à-vis the rest of the world. So that's the context in which the 86 Act has to be seen. And how does Brussels II revised deal with that problem? Because it's presumably dealing with member states.
Yes.
Scotland is not.
No,
yet,
it doesn't.
Separate member state.
It does not alter the rules about determination of jurisdiction between component parts of the UK. As Milady will know, another member of the court may know as well, and we've recited it, referred to it in our document. There's a lot of unhappiness about the drafting about the current state of section of the 1986 Act, and Lord Justice Thorpe refers to that as well.
But arguments about this would arise under the bottom right-hand corner. Would it be no court is competent under the regulation?
Well,
because one would need to know. I mean, you see, at first blush, one would say, well, all right, the United Kingdom is a member state, and you can see that it's not anything to do with other member states, but there's still this argument within the United Kingdom.
Well, yes.
But this isn't designed for that at all. This is a guide to the regulation, after all.
The regulation does not help with the determination of the question of jurisdiction between the various states, countries, jurisdictions within the UK. That is still determined under the law, under the residual laws. That doesn't, of course, arise in this case. Does the court wish me to say anything more about the primacy of the Brussels jurisdiction?
Is Article 66, which deals with member states with two or more legal systems, does that help?
Let me just Article 66.
66.
Right.
It's a bit of a red herring in this case, of course, because nobody is suggesting that there's a dispute between Scotland and Wales or Scotland and England. But it does help to put the 86 Act in context of what it was originally for.
Yes. Well, it gives you some sort of a guide, but not...
I confess, my Lord, that I had not fully prepared an argument dealing with that point.
No reason why you should.
Having had to read large sections of Dicey and Morris, my Lord, for the preparation of this case, I have had to concentrate on points I thought your Lordship might raise. I confess that was not one of them. But anyway, and it's an interesting point. No doubt will arise in a future case.
So the primacy point we can really leave there, can we? I mean, it does raise huge issues, as you know, in other areas of the law, and we've struggled to find an answer to things, for example, stays in arbitration proceedings and so on. But we've had an answer from the Court of Justice on that point already.
Well, what I say, my Lord, is that if it's right that the jurisdiction is derived from Brussels II revised, then Brussels case law, is relevant in the interpretation. And in particular, Brussels case law about habitual residence and forum non-conveniens would be relevant if in issue. So if the court were to feel it necessary to look at those issues, that would then become relevant.
Yeah. Well, there's no doubt that habitual residence must be given an autonomous meaning.
Within the community.
Yes. And we now have guidance.
From the latest case, European case, which still only has a number, which which I've not memorised, has defined, provided a different definition for the habitual residence of the child. Query to what extent, if at all, that impinges upon habitual residence, definition of habitual residence of the parents, which of course might be relevant in certain circumstances under Article 12(3).
Well, it doesn't matter here.
It doesn't matter.
It doesn't matter with the grandparents and an aunt.
Unless you're going to be tempted by those to my left to consider that point further. Well, I certainly won't be developing it at this stage. Now,
So, have I got this right? I mean, if your arguments are wrong under Article 12, what then?
if my arguments are wrong under Article 12, then this court has no these courts have no
That's the
jurisdiction.
end of it.
Yeah.
You're not relying on any residual jurisdiction.
No. We don't seek to challenge Judge Barnett's decision. So I turn then to
Would that be
prorogation.
the position before the 1986 Act?
With that,
Well, under the old law, before we had any of this.
well, under the old law, I wouldn't be here. We wouldn't be here. We might have.
Because?
Well, because we, as we now accept, the court has had no jurisdiction.
But under the pre-1986
Yes.
law,
pre-1986 law. Oh,
jurisdiction
sorry.
in wardship could extend
Yes,
on the basis of allegiance.
yes. Parents
And we are
patriarch.
talking about British citizens.
Yes, that's true.
So there was a potential, but of course forum and inconvenience would come in there, big time.
Yes. I'm sorry. I thought your lordship meant under the.
No, I meant before the 1986
Well,
Act.
before the 1986 Act, Ms. Milady is absolutely right. It would be a different. It's a different work.
Getting some nods for the observations.
Different
there,
lifetime.
don't
I think it would be the case that it would be seen as parent patriarch. The child is a citizen, and the court would have a discretionary jurisdiction. Would have jurisdiction, but would have a discretion whether or not to exercise it. Of course, forum non-convenience itself has not been recognised in English courts for an enormously long period of time, and of course, wardship itself was itself not recognised as quite having the expansive effect that it.
Oh, it had a lot of effect on cross-border situations, and of course, some of our standard practices, like the undertaking given by the father in
Developed
this
in
case,
wardship.
will have developed in
Yes,
wardship.
but
Precisely for that reason.
I was going to say relatively recently. Anyway,
What is the current status of this undertaking? Is it still extant, or is it somehow been overtaken by...
Still extent.
it is.
Better ask Miss Russell what she thinks about that.
I think
What's your submission?
our submission is it still extant. Yes.
So that the application could still be made for your client, order directing your client to take all proper steps wherever in the whole world to procure the return of the child for some reason or other.
Yes.
In accordance with his previous undertaking.
Enforcement would be yes.
Well, it could be enforced by sending the father to prison.
Well, it could. He of course would seek to be discharged from that undertaking and seeks orders.
Well, that's a different question. I'm on the question of what the position is while it's still extant.
Yes.
But it hasn't been discharged.
No.
Is this right? By operation of law. And nor would it be, is this right, that if this application had been made as part of the matrimonial proceedings, it's been an Article 12(1) case, what would be the position? And if the order which was originally made is one that extends indefinitely, what would the position be then?
Right. Well, let's look at Article 12(1), and we have to consider Article 12(2), which.
Article 12(2) depends what meant by the jurisdiction shall cease.
Yes.
If the jurisdiction has already been properly exercised, why would not any ancillary question, like what variation there should be during the minority? Suppose the original order was during the minority.
Well, the order. Look at Article.
There's some very bizarre features of this, aren't there?
Yes.
One is that unlike in other areas of the civil law in Europe, they have a sort of article, this is Article 15, which enables the matter to be decided in any court in the community, which of course is contrary to what position was under the ordinary civil laws.
Yes, Article 15 is...
Curiously, that's okay, unless the sensible place to have the matter determined is outside the member state. Then we rely upon our own jurisdiction, which is for some reason extremely narrow.
Yes. Well, your Lordship's absolutely right. There are some strange features of the law it is now not clearly that the European Court and no doubt national courts are trying to work through the apparent illogicalities. And I was just trying to think through, if I may.
The matters however act clair here.
I'm sorry?
The matters act clair.
Well, I say it's act clair. I say it's act clair. I don't encourage the court to take the course of a reference.
Yeah.
The prorogation. If you look at Article 12.1, 12.1 gives the court jurisdiction, gives a prorogation jurisdiction in matrimonial cases, but that ceases as soon as the marriage comes to an end, the divorce proceedings come to an end. Alternatively, where the PR proceedings are still pending at that point, a final judgment is made, or the proceedings come to an end for another reason. So a final judgment, the question your Lordship poses, supposing the order is a contact order, a month the child is brought to this country for a month in the summer holidays until further order. Is that the end? Is that a final judgment?
Well, what is it talking about in paragraph 2A? It's when the judgment becomes final, allowing or refusing the application for divorce.
That's, yes. B.
But we're on B, are we?
Yeah. B is
Yes.
where you have the PR proceedings, in this instance,
Right.
the contact proceedings, ongoing after the divorce is off.
Oh, still pending. Yes, I see. Yes.
That continues until a judgment in these proceedings, it says, has become final.
So if you had an order a written order which dealt with the whole of the child's minority with a liberty to apply, for example.
Yes. Well, that's. I don't know the answer to that question, my Lord.
I guess not the question.
It's an interesting.
Articles 12.1 and 12.3 have to be considered together.
Yeah. Well, of course.
No.
I mean,
On a narrow interpretation, once a narrow interpretation, once you've got a final order, even if it could be, if there's liberty to apply, that's a final judgment, and the jurisdiction comes to an end, and you'd have to invoke other jurisdiction, presumably 12. At that point, it would be 12.3, if you could, in order for the court to have jurisdiction.
Can you just remind me of the date, the final date in the matrimonial proceedings?
Well, we don't know when they were.
May I turn around?
Yeah. I don't think we have a date at all yet.
No.
I'll find out.
Is it common ground that whatever else we're concerned with here, we are not concerned with the matrimonial basis of jurisdiction?
No. Although
That's common ground.
We are.
Yeah.
Although I do take my Lord Clark's point that no doubt the court will look to see how they interrelate.
Well, you need to know that to get into Article 12.3, don't you? Because it says this is in
Yes.
proceedings other than those referred to in paragraph 1.
Yes.
But
Well,
if
in
it's
this
common
case,
ground,
in this case, it doesn't arise because there was nothing like a liberty to apply provision, which could possibly be regarded as enabling the proceedings to continue on any interpretation.
Isn't there a better answer that no orders relating to this child were made in the course of the divorce proceedings?
Yeah. Yes.
This was
Well,
not.
well, I don't know whether that's right.
Well, we need to find out.
I don't know that. I'm assuming not, because of course the care proceedings were contemporaneous with the divorce proceedings, and I'm assuming it was dealt with. I don't know the answer to that. I will check. I'm sorry.
You have to say something about children in the divorce.
You do.
But you don't have to make orders. The whole point is you don't make orders most of the time, and most of the orders are made independently under the Children Act.
2002. Yes, that was
Yeah,
still
that's the general
Yeah.
proposition. And so it would be unlikely for there to be orders that were made in the course of the matrimonial proceedings. And in any event, where there are care proceedings going on contemporaneously, they're definitely separate from the matrimonial proceedings. And the fundamental order in this case, the residence order to Dad, was made in the care proceedings,
Yes.
And the
which must be why it's common ground that we're not concerned with the matrimonial basis of jurisdiction.
And
That's
historically, the care proceedings had begun before the separation, hadn't they?
Yes.
So they were ongoing.
Yes. I've not. Yes, I will just check your lordship's right. We need to know exactly. I will check that.
As we can see a copy of the order which brought the matrimonial proceedings.
Yes.
That would be the decree.
Decree absolute, and whatever order, if any, was made so far as the child was concerned. I suspect there was none, but I'll have to check.
There would be the usual certificate.
There would have been yes.
Section 41 certificate.
Would it be in the same form as now? Yes, it would, 2002. Anyway, so that's how do we get onto that? Oh yes, I'm now moving on to the prorogation powers, so at this point in our argument that we touch on habitual residence, but I've said more than I intended to at any rate about habitual residence, and I'm going to leave that part of the argument to Mr. Devereux.
So we're on to
In my case,
paragraph 45 now.
yes, that's right. The first question to be considered under Article 12 is whether the power to prorogue jurisdiction extends to children who are habitually resident in a state that is not a member state of the EU. The rationale for Article 12 is to provide an exception to the general rule that jurisdiction in matters of PR is conferred on the member state of the child's habitual residence. Article 12, as we've already identified, provides two powers of prorogation in matters of parental responsibility, one in matrimonial, the other in non-matrimonial proceedings. This case concerns a non-matrimonial case. The first issue arising is whether that power is confined, as is contended on behalf of the father, to children who are habitually resident within the EU, or extends to all children, as we contend. And if the latter construction is correct, jurisdiction could be prorogued to cover Q, provided the criteria in Article 12.3 are satisfied. Before I turn to the question of third state, could I just invite the court to look at Article 12.3 and its predecessor. Article 12.3, which you have open in front of you, reads, well, the first part of it reads, the courts of a member state shall also have jurisdiction in relation to proceedings other than those referred to in paragraph 1. Now, its predecessor was Brussels. I've realised I've also not, in the course of the argument, gone through the history of the Brussels regulations. That is set out in full in my document. I assume I needn't do that. The predecessor to Brussels 2 revised was, of course, Brussels 2, and that is at tab 6 in the Authorities Bundle Volume 1. And the comparison I wish to draw is, in fact, between the old Article 3 under Brussels 2, and in fact, strictly, it's the matrimonial jurisdiction, Article 12.1. Because, of course, there was no equivalent to Article 12.3 in the Brussels 2 regulation. So if I could invite the court to have Brussels 2 at tab 6, Article 3.1, and Brussels 2 revised, Article 12.1, open and compare the two. So tab 1 and tab 6. Brussels 2, Article 3.1 says, the courts of a member state exercising jurisdiction by virtue of Article 2 on an application for divorce, legal separation or marriage annulment shall have jurisdiction in respect of matters, in a matter relating to principle over a child of both spouses where the child is habitually resident in that member state. 2, where the child is not habitually resident in the member state referred to in paragraph 1, the court of that state shall have jurisdiction in such a matter if the child is habitually resident in one of the member states and then the two tests are set out. At least one of the spouses has PR and the jurisdiction has been accepted by the spouses and is in the best interest of the child.
The word prorogation is not used
No,
at all in the heading or anywhere else
no,
in this regulation.
it's not. But the point is that I seek to make is that in those circumstances, under Article 3, there is an express reference to habitual residence.
Yeah.
So where the child is not habitually resident in the member state, the court of that state shall have jurisdiction in such matters if the child is habitually resident in one of the member states and the tests are satisfied. Hurdles are satisfied. Contrast Article 12, which of course is headed prorogation. The courts of a member state exercising jurisdiction in divorce, etc. proceedings shall have jurisdiction in relation in any matter relating to parental responsibility connected with that application where, and then the hurdles are inserted. So there is no reference, no restriction there to children who are habitually resident in one of the member states. And in our submission, there's no justification for reading into Article 12.1 or, importantly for this case, Article 12.3, the phrase, in respect of a child who is habitually resident in a member state. Sure, this isn't too rhetorical a point. If the authors had intended to limit the scope of the jurisdictional rules to cases where the child was habitually resident in the member state, given that they said so in Brussels 2, we submit they surely would have done in Brussels 2 revised.
Well, another way of putting that is that the omission must be presumed to be deliberate.
Yes, Lord, and that's the first point.
But we're back, aren't we back to the meaning of third state in Article 12?
Well, I'm now moving to that, milady, and that's the central issue, the first issue between my friend and myself. And of course, the short point is we say third state means non-member state. In short, we say it's a term of art in EC law to mean non-member state.
And if so, 12.4 provides that it's possible for jurisdiction to
Precisely.
arise under the foregoing provision.
12.4 only makes sense if we submit. It only makes sense if 12.3 applies to children who are habitually resident in third states. But maybe we're jumping ahead, forgive me for saying so, because it is contended on behalf of the father that third state does not, in this context, mean non-member state.
Yes, I understand that, but as it seems to be rather crucial to the argument of construction.
Well, it's because we say it's absolutely clear. We've cited a few examples, a rather long passage from the Génard report to illustrate it, but there are numerous other examples in EU law of third state being used to mean non-member, meaning in the context of non-member state. And there is we've been unable to find any conceivable, possible interpretation of that phrase in any case or EU legislation to mean anything, for any construction, possible construction of third state meaning anything other than non-member state.
But you've said, and I think this may be right, Miss Russell will tell us later, that she is saying, well, that may be all very well in other contexts, but when we're looking at this particular context, third state must mean a member state.
Well, my lord, we submit that it's a term of art which is only capable of one meaning.
Well, I think your response to that is it's perplexing when it had been used in the precursor of Article 12, the expression member state, first of all, that it was omitted, and secondly, that a different term was adopted.
Exactly. The trouble is, Lord, I've got quite a number of reports, and it's difficult to know which ones to put forward.
That might start.
Article 6, it's not defined. Would that it were defined conclusively, and one might, Mr. Setright, I know, is going to invite the court to perhaps to suggest possible amendments to the regulation, and certainly a definition section seems arguably, or a definition of the phrase seems maybe necessary, that we say it's not. We say it's clear. It's only mentioned twice, the phrase third state, in the regulation. And the second instance in Article 61. And we say this demonstrates beyond any conceivable argument, with respect to that friend, that third state means non-member state. Article 61 is about the relationship between this regulation and the Hague Convention, 1996 Hague Convention, on the jurisdiction, applicable law, recognition, enforcement and cooperation in respect of parental responsibility and measures for the protection of children, which I shall call the 1996 Hague Convention for short. It reads as follows: as concerns the relation with the 1996 Hague Convention, this regulation shall apply A, where the child concerned has his or her habitual residence on the territory of a member state. B, as concerns the recognition and enforcement of a judgment given in a court of a member state on the territory of another member state, even if the child concerned has his or her habitual residence on the territory of a third state, which is a contracting party to the said convention. In other words, the regulation always applies where the child is habitually resident in a third state. And in addition applies where the child is habitually resident on a third, i.e. non-member state, as concerns the recognition and enforcement of a judgment given in member state A on the territory of member state B. There is no possible way that we submit in which third state in Article 61 can mean anything other than non-member state. And it would, in our submission, be astonishing if any other interpretation was possible of the other reference to third state in the regulation.
For the slower members of the class, could you just indicate the nature of the Hague Convention and why it is that Article 61 seems to relate to cases where the Hague Convention, if you like, applies, whereas Article
12.4.
Relates to a third state which is not a contracting party.
Yes. Well, that is. I will do my best to explain my understanding, which is, I would say, my Lord, is totally imperfect as to the interplay between these regulations. The Hague Convention, 1996 Hague Convention, is in the bundle at tab 4, so a few tabs in the same bundle. The Hague Conference, this is a convention under the Hague Conference, and it is for, as it says, jurisdiction, etc., in respect of parental responsibility. And it makes a number of provisions which are very similar to the provisions of the Brussels II revised regulation.
And the state parties are... Where do we have a list?
I have a list, and I defer on these points to Mr. Setright, who always has a more up-to-date list. But my list of those countries where it is fully in force, that's to say signatories and contracting states, is that the right phrase? Well, Mr. Setright says 17, I have 10. But it has a number of European states, number of states, the member states, and a number of states which are...
Lord Justice Thorpe, I think, said that 10 EU states were
Yes,
parties.
that may have come from me, so it may be unreliable. But
Yes.
10 EU states. I don't think... Is it 10 EU states? Well, Mr. Setright and Lord Justice Thorpe will know more.
It might be helpful to have it on a piece of paper.
Well, I've got it on a piece of paper, but Mr. Setright's more up to date than I am. The last document we had, 10 states. But what is clear is that there are some European states and some non-European states that are fully parties to that convention.
And of course, I would have to have in mind the timing of the enlargements, because am I not right? It was concluded. The Hague Convention was concluded in 1996.
Yes.
And then it came into force in 2002. And I haven't got my timing clearly right, but the latest enlargement was after 2002.
EU
Yes.
enlargement. Oh yes, it was.
Well, the parties will be on the Hague Conference website.
Yes, they will.
Yes.
They will.
Tab 75 in Mr. I haven't got red tab 75. That's Mr. Setright's. No. There's a status table at tab 75 in Mr. Setright's bundle. We've not got it. I haven't looked at it.
It's in loose leaf bundle.
Now there is, my lord.
Oh, I
The
see.
most
Yes.
important point is whether Pakistan is a party. to
Yeah,
that
it's not.
convention. And you would stagger me if it were.
But Ukraine,
Well-
and Switzerland and Norway.
Right.
Norway isn't there, but Ukraine.
Again, Mr. Setright will perhaps be able to enlighten you more than I can, but there's an issue as to whether or not the EU now has competence in respect of international conventions. The position, as I understand it, is that it does not have competence to ratify, on behalf of the member states, this convention. The member states have all signed, but only some of them have ratified. Is that right? They've all signed, but only a few of them have ratified the convention. Now,
Let's going back to a point about third state. What if it meant, for example, Italy? What would the word third mean?
well, third, in my submission, usually means, invariably means in the legal context, a party, in third party, for example,
Yes.
who is outside the
Yes.
contractual framework. And that's what third state means here. And again, Mr. Setright makes this point, we had already identified it. My learned friend refers to the very recent regulation dealing with the so-called third countries point, a regulation which is also in the bundle at tab 7, which is to establish a procedure for negotiation and conclusion of agreements between member states and third countries.
Yeah.
And my own friend Ms. Russell suggests that third country is used to mean non-member states, and therefore seeks to draw a distinction between that phrase and third state. We, with great respect, adopt Mr. Setright's point that the important word in third country is not the word country, but the word third, which has the same meaning we submit as in third state, as we've just discussed. I've discussed with Lord Collins.
Yes.
We have endeavoured to find some academic support, and in paragraph 52, we quote a passage from Cheshire, North and Fawcett, latest edition, when they summarise Article 12.4, they don't bother with the first phrase, third state, they use non-member state in lieu. There's a book by Dr. Talia Kruger called Civil Jurisdiction Rules of the EU and Their Impact on Third States. which I apprehend some of the court, Lord Collins in particular, may be familiar with, she uses the phrase third state to mean non-member state throughout. She's from South Africa, and she begins her preface with the striking sentence, coming from a third state myself, I was stunned by how much the European Union has achieved, especially in law. And the practice guide at tab 2 in Brussels, the practice guide to Brussels 2 revised, we submit, makes it equally clear. If you look at page 45,
Sorry, just remind me, where is the practice guide to be found?
tab 2 in the authorities bundle, the first volume 1. Now, of course, the practice guide is not binding, so only of illustrative, perhaps persuasive authority. Certainly, the understanding of the authors of the practice guide was that that our interpretation is correct. Bottom of page 45, describing Article 12.4, as described in Chapter 2, Article 12 of the regulation introduces a limited prorogation option for a party to choose to seize a court of a member state in which the child is not habitually resident, but with which the child has nevertheless a substantial connection. This option is not limited to situations where the child is habitually resident within the territory of a member state, but it applies also where the habitual residence of the child is in a third state that is not a contracting party to the 1996 Hague Convention.
So it's the little a before member state in the second line that's the important bit, is it there?
Yes. We say that that clearly contrasts third state with a member state. If, of course, it's only persuasive authority, but we submit that that, coupled with the obvious interpretation of Article 61, illustrates that third state in Article 12.4 means non-member state. Where that gets to, my Lord, is a matter which I will consider next. Would it be helpful, I note the time.
We don't have a clock, I'm afraid, at the moment. It's about 3 minutes to 1.
I was going to would it be helpful if we just identified the documents that the court would be assisted by our producing? We've mentioned the divorce documents, so the decree nisi and absolute, any children's order. Yes. I'm reminded by Mr. Devereux that she was acting in person, both parties were acting in person at that point. Are there any other documents the court would be assisted with from the history?
Well, for myself, no, I don't know that anybody else is volunteering anything else, but that is obviously very important to see the terms of the order.
Do we have the various documents which are said to be attached, for example, to Mr. Justice Headley's order? Maybe we locate it.
I'll locate attachment to Headley Jo's order.
Yes. Well, I have the sense that you would prefer really that we adjourn now, because if we're starting a new topic, it makes sense to begin afresh at 2 o'clock. But may I say this, that one of the features of coming on so early is we haven't had, as we usually do, a table of the times that parties are expected to occupy in the time available. Normally parties are expected to have some kind of thing, and then we can see how time is going. Could everybody apply their minds during the short adjournment just to see how the available time can best be divided up so that everybody has a fair shot?
Can I reassure the court we have considered that? We have discussed that, but we took the view, it would be easier to gauge it once we'd seen the ambit of the,
well, I'm sure that's right.
issues which the court wished to consider.
I think we can keep it on
the range of issues which were raised on paper.
Yes, well, we keep it under review, but all I'm saying really is we need to be very careful not to squeeze too much at the end of the argument, particularly as the intervener is coming at the end, and we may want to hear a bit from him.
Yes. Yes, my Lord. Well, we'll consider that now.
Yes, thank you very much. Well, we look forward to seeing you again at 2 o'clock.
Thank you, my Lord.